Welcome, everyone. My name is Angie Garberding, and I'm with Disability Law Colorado. I am a middle-aged white woman with long, wavy blonde hair and some pointy black glasses. So before we get started, we did want to join all Americans in mourning for the victims of 9/11 and for the shootings that have happened this week, and wishing for an end to the violence that darkens our nation every day. We are so glad you could join us for tonight's Back to School, What You Need to Know in 2025-2026 webinar. This program is designed to help families, educators, and advocates stay informed about policies and programs that shape the lives of Colorado students with disability. Before we begin, I just wanted to say a little bit about Disability Law Colorado and our partners before we get started with kicking off the program. So first I wanted to give a few words about us, who we are. We're Disability Law Colorado, and excuse me, we are Colorado's protection and advocacy system. There is a protection and advocacy organization in every state in the union, and we have been part of the protection and advocacy system since 1976. We're committed to safeguarding the rights of people with disabilities. Some of the things that we do is advocate for access in schools and work situations, home situations, your health, community, everything like that. We also have a QR code. We rely on donors and institutional givers to fund our efforts like policy advocacy and education. So we do have a QR code if you would like to donate to us. The QR code will show back up again at the end of our presentation as well. Next, I would like to talk a little bit about our supporting partners. We also want to thank the Colorado Bar Foundation, who provided funding for this and other online events hosted by Disability Law Colorado. And then also give a shout out to Denver Human Services for supporting DLC's community-based work through its Ideas Voices grant. And also, if you are a Denver resident, please take out your camera and scan another QR code to answer a resident feedback survey to help Denver Human Services gauge if they are reaching Denverites with intellectual and developmental disabilities through their grant program. And again, this is for residents of Denver only. And then finally, I would like to recognize our champion sponsor, the ARC Arapahoe, Douglas, and Elbert counties. This organization has served its community for more than 70 years with a mission to use advocacy and education to include all children and adults with disabilities in their communities. They walk with people through every stage of life, from birth to adulthood and into aging. Their work is both personal and systemic, supporting families one-on-one while also advancing laws and policies that make Colorado more inclusive. If you live in their region, we encourage you to visit their website, and we're super grateful to have them as a partner for this presentation. And then finally, I want to welcome our presenters. I'm excited to introduce you to two of my coworkers that work at Disability Law Colorado. Emily Harvey is one of our co-legal directors here, and she is an adjunct professor, a nonprofit leader, and she's also a children's book author. And then next is Sara Pielsticker. She is a disability rights attorney at DLC with a strong background in education and disability policy, who spent her career promoting inclusion in Colorado. And we're thrilled to have both of them here to share their insights with you today. And with that, I'm gonna pass it on to Emily and Sara.
Great, thanks for that intro, Angie, and thank you all for coming. We're thrilled to have you here. To start, I'm just gonna go over an agenda that gives you an overview of what we're gonna be talking about today. So the first thing we're going to go through is what state and federal changes have been happening that we think you need to know about. Then we're going to talk about what dispute resolution options are available, how any of those have changed through these state and federal changes that we'll be talking about. Then we'll be talking about current gaps in services and oversight that we are seeing. Then we'll close with some practical tips for you all to have in your pocket this school year, and future advocacy efforts that are in the works. And then, of course, at the end, we'll have some time for questions. We'll only be answering the questions that were sent in advance of this webinar, but if additional questions do come up, please feel free to contact our office and we'll see if we can answer them. Now let's dive in. I'm going to start by talking about some state changes. I really thought it was important to talk to you guys about some recent legislation. I'm just going to go over some bills that were passed in the last 2 years. The first one is House Bill 24-1063, which talked about abbreviated school days. An abbreviated school day can be a lot of things. Some examples are if a school district or a school, is calling you every day to pick up your child at a certain time, or maybe a child is sent home every day for a behavioral reason, but it's not labeled as a formal suspension, kind of anything that's not quite a formal suspension or expulsion, that can all be looped into an abbreviated school day when a child goes to school for less time than their peers. This bill did not cover kids who are, missing school due to medical needs, only who are missing school due to kind of administrative reasons. The bill provided a lot of protections for parents if their children are having their school days abbreviated. One big thing is that parents need to consent if their children are going to be placed on abbreviated schedule, and there needs to be plans for kids to go back to a full day schedule if a school wants to place them on an abbreviated day. The other big thing that this bill did was provided staff to the Colorado Department of Education to provide technical assistance to school districts about this law and about how to properly support families and implement or not implement any abbreviated school days. The last thing this bill did was just collect data on how often this is happening, so we know if it is a bigger problem in Colorado. The next couple of bills are all bills of rights that are passed for youth in different capacities. These were all passed in 2024. It was a big year for rights of kids, which we love. The first was House Bill 24-1170, which is the Bill of Rights for youth that are in the Division of Youth Services. So really, we just codified into law what is in policy with the Division of Youth Services. For example, the right to vote, the right, if they're eligible, the right to receive an education, the right to feel safe in their environment, the right to receive phone calls, that kind of thing. The second was House Bill 24-1017, and that is the Foster Youth Bill of Rights, which just provides information about rights that youth who are in foster care have, in no matter what setting that they are in. The last Bill of Rights that was passed in 2024 is House Bill 24-1216, and that's supports for youth in the juvenile justice system. This bill actually did a little bit more than just provide rights. They also created a hotline that families and community members will be able to call to get supports for students who have been justice involved. This bill is really championed by our friends at Generation Schools, and they've been doing a lot of work on the ground to make sure that this bill has been implemented to really support youth in our community who have been justice involved. The next bullet on here is restraint and seclusion. I'm going to save that for the last bullet so that Emily can talk about that, because she really spearheaded this last year. So we'll come back to that one. But then to talk about the mandatory reporter task force bill, that was House Bill 25-1188. There was a mandatory reporting task force that met over the span of 2 years that talked about reforming the mandatory reporting system in Colorado. And they give a lot of recommendations in their final report, and some of these were implemented through this legislation. The really big one for us as a disability rights organization was that it is now in Colorado law that you can't file a report strictly on someone because of their disability. The last note I wanted to mention that has been heavily talked about at the state level is that we have a lot of budget constraints as a state. This is going to continue on into next year, and so that just kind of affects any legislation that you might see coming through the pipeline. And I know that our legislators are hard at work to figure out how to make everything keep functioning in Colorado through these different budget constraints. So I'll pass it to Emily to talk about restraint and seclusion.
Thanks, Sarah. And since I haven't talked yet, I'm a 40-year-old white woman with brown hair wearing a black shirt. And I'm going to talk just briefly about the restraint and seclusion bill, which was House Bill 25-1248. It just went through this last session. And it cleaned up some issues that had come up around data reporting, specifically for seclusion of students with disabilities. And it also took everything that was previously in the Human Services Code that was relevant to schools and put it in the Education Code so that when future changes are looked at, it is part of the Education Code that people who are concerned about education are looking at and paying attention to, because some of the issues that had come up through rulemaking were because it had been in the Human Services Code, which is a different part of the state law, and the education people weren't really looking at it when they were changing it for human services. So just flagging with restraint and seclusion, this was a cleanup bill. We took a lot of things that were in rule and put it into law so that it's harder to change in the future. And physical restraint, so holding a child, and seclusion, putting them alone in a room from which egress is involuntarily prevented. Those things are only allowed in Colorado if there's an emergency, which means there's an imminent danger and the child could actually do the thing that you think they're going to do. So they're still, those two types are still allowed, but this bill did clean things up and set us up to potentially make future positive revisions for kids down the road. We're going to switch gears to federal changes. There has been discussion of potential block granting where they take pools and streams of money and put them all together and give them to the state. And this is something that they've tried to do in the past unsuccessfully. We don't exactly know where the budget is going to fall. There's been some discussion of cutting the funds for Individuals with Disabilities Education Act. There's been some discussion of level funding, and they're supposed to have a budget finished by the end of this month. So we'll see. The other possibility that we may see that we've seen in the past is that they aren't able to pass a full budget and they do what's called a continuing resolution and get us to maybe the end of December. So we don't really know what's going to happen. But the important thing is that federal law and your students' rights have not changed. The laws that protect students still exist as they did a year ago, 2 years ago, 3 years ago. The thing that has changed is enforcement. So some of the federal laws that protect students with disabilities, particularly from discrimination, harassment, retaliation, students with Section 504 plans, but also students with individualized education programs, are federal laws called Section 504 and the Americans with Disabilities Act. And those two laws, in addition to laws that protect against discrimination based on race, national origin, and gender, have historically been enforced by the U.S. Department of Justice and the U.S. Department of Education's Office for Civil Rights. On the Department of Justice side, we don't have a ton of information, but we do know that at least in a case that we have pending an investigation at the Department of Justice, we previously had 5 specialist attorneys and data analysts working on the investigation. We've been notified that only one of those people has continued on the case with an additional DOJ staff person who we're not sure of their background. So what we have heard is that the sections at the Department of Justice that investigate disability claims have been gutted and or their staff reassigned to areas that they're not experts in. So Our understanding for the Department of Justice is that there's just not as much staff there to do enforcement and investigations. The Department of Justice has never had an obligation to look into every complaint that they get, but they were, at least the last few years, very interested in systemic restraint and seclusion work. And they had been requiring school districts to ban seclusion. So we don't really know what it's going to look like in the next couple years, but definitely a decrease of enforcement on that end. The big place that we would go for discrimination complaints, harassment, bullying, retaliation, 504 issues, equal access issues, architectural accessibility has historically been the Office for Civil Rights. And they, a few months ago, had 7 of their 12 offices closed with all those staff terminated. In addition, we've seen a great reduction in the staff that remain in the Denver office. So the Denver regional office still remains, but I suspect that they have about a third to a half of the staff that they used to have. And they just don't have the capacity that they've previously had. So we're seeing less enforcement on that end, although I did hear from some school districts today that they are still hearing from the Office for Civil Rights and being contacted about ongoing investigations. So it seems that some of that work is continuing. They've issued a uniquely large amount of dismissals this year, and they have resolved a lot less than usual cases, like actually coming up with a resolution. And they have the ability to do what are called directed investigations, where they pick who they're going to investigate and what they're going to investigate. And it seems like they're doing quite a bit more of that, specifically around gender and bathroom issues. So the enforcement piece is really, I think, where we have seen a lot of potential changes at the federal level. That said, we do encourage people to continue filing. We don't want there to be any record that these places are not needed or valuable because complaints are not being filed. So you should still file with the caveat that you might not get a resolution. I will also say neither of these entities have ever been perfect. They've had their flaws. They've taken a long time to get resolutions to families. So our hope is that eventually, if we build these back, we can build them back in a way that's more effective for families, but that will be to be determined. And with that, I will pass it over to Sara.
Thank you. This is Sara speaking. So I just wanted to talk briefly about the dispute resolution options that are available to you in the education space. I'll kind of go over them a little quickly, but if you love hearing Emily and I talk, we have an additional 40-minute video on our YouTube page about different dispute resolution options in both English and Spanish. And we also have additional information kind of giving some pros and cons of these different processes on our website. So I'll give a little bit of a high level overview, but there is additional information out there if you would like some. Emily kind of touched on the Office for Civil Rights and Department of Justice and the laws that you can file complaints with, or the laws that those entities have jurisdiction with which you can file complaints with. I think the only important thing to note is that the Office for Civil Rights does have a really tight statute of limitations. So you can only file with the Office for Civil Rights for things that happened in the last 180 days. I guess I shouldn't say only, because you can file beyond that, but you need a special exemption, and sometimes they aren't as willing to forgive kind of those extensions. So it's really important, if something happens, you want to file with OCR, that you do it as soon as you can. DOJ doesn't really have as strict of a timeline, but they also can be a lot slower to get back to you. Like Emily was saying, both offices are operating with a reduced capacity. So they might take a little bit of time to get back to you regardless. Then the Colorado Department of Education, so they're really suited for complaints related to the Individuals with Disabilities Education Act, or Colorado's version of this, which is the Exceptional Children's Education Act, and then the Restraint and Seclusion Law cleanup that Emily was talking about earlier. So they oversee kind of issues related to maybe failure to implement an IEP, or if a child was inappropriately restrained or secluded, or you as a parent weren't notified. All of those issues can go in what's called a state complaint through the Colorado Department of Education. And they are pretty quick actually at getting back, and they stick to their timeline. So once you file with them, they have 60 days with which to issue a decision. They'll really go through a big investigation. If they find violations and open an investigation, they'll do all kind of the legwork. So they'll get the documents you need, they'll do the interviews, and it's a very parent-friendly process in that regard. And so it really just allows you to tell your story, and then they'll figure out if a violation occurred or not. You can also do a variety of other dispute resolution mechanisms through the Colorado Department of Education, such as mediation or requesting a facilitated IEP meeting or individualized education program. And you request those, you can request them through the website. The thing I like to note with that is that the school district does have to agree to that. So it might sound like a good idea in theory, but then maybe they aren't willing to come to the table. And, the really important thing to keep in mind if you choose mediation or facilitated IEP meeting or another low-level option is just to keep in mind the timelines for all of these other complaints. The state complaints do need to be filed in 1 year of alleged violation. So it's still a good option at the state level, since some of the federal since some of the federal options aren't, as responsive right now, but it oversees different laws and might oversee different issues. And so that's why it's important to know kind of what you can go to them for and what you can't. The last two dispute resolutions options I wanted to talk about were disputes through the Colorado Civil Rights Division, or CCRD. So they oversee what's called the Colorado Anti-Discrimination Act, or CADA. Here you're really looking at kind of our state level discrimination laws and violations of that. They have a really, really tight timeline, so you have to file within 60 days of alleged discrimination that occurred. They might have different timelines for other complaints that can be filed, but it's important to kind of look at that and think about that more quickly if something occurs that you'd like to file with them for. Because we used to have we still have the Officer of Civil Rights, but because of their reduced capacity to handle complaints with schools, a lot more of these are going to the Colorado Civil Rights Division, and they, have a reduced capacity because they weren't previously handling as many of these complaints. And so when you hear back, how you hear back, it can kind of vary, but that's just something to keep in mind. The last option I wanted to mention is a lawsuit. I think the important thing to keep in mind if you want to pursue a lawsuit against a school district for anything is just that you may need to exhaust lower level remedies, and all of that is just, within different statutes. So for example, if you want to sue a school district for something related to the Individuals with Disabilities Education Act, you might need to pursue due process and exhaust that option first before you can pursue a formal lawsuit. It sounds really complicated, but if you talk to an attorney, they can help walk you through that. So again, if you want more information on any of that, you can watch our other video or look at our other information online, but that's just the high level overview for you.
All right, thanks, Sarah. So I was going to talk a little bit about the current gaps. I already talked about the enforcement piece, so I don't think we need to dive into that too much here. Just to say, again, that it seems that Department of Justice and the Office of Civil Rights at the Department of Education have reduced capacity to enforce the laws that they have been given by federal law statutory authority to enforce. So the other thing that the Office for Civil Rights in particular has done a lot of in the past is training and technical assistance. So you could request a training from them as a school district, or as an individual, you could call in for technical assistance. And that was a good way to get the information needed in order to resolve concerns and better understand the law so that a complaint was not necessary. And that is at this point not happening. So there's a lack of training and technical assistance for people seeking information about these laws at the federal level. Sarah mentioned mediation through the Colorado Department of Education. The Office for Civil Rights also has the ability to conduct mediations, as does the Department of Justice. And with the reduced capacity, we just aren't sure how effective or available that's going to be to people. So there are seemingly less options for resolving things through mediation. And then court capacity. So, like I said, these laws have not changed. So, students' rights have not changed, and courts can enforce the laws. So, state courts can enforce state laws, federal courts can enforce federal laws, and that is still true. But there's not a huge capacity for courts to take these cases, and they take a long time. And there are not a lot of attorneys in Colorado who do education cases. So that again goes to the enforcement piece. And it sounds like the Office of Civil Rights may be doing more mediations than I suspect. So that might still be a good option on the table for people. All right. Future advocacy. So what are we doing? We are currently working with Senators Kolker and Michelson Janae and Representatives Bacon and Phillips to look at increasing protections and enforcement in state law. So taking the laws that have been federal, taking that language, we can't give the state authority to enforce federal law, but we can take the language of federal law and put it into state law. So protections and enforcement around discrimination, different treatment, the bullying, retaliation, students with 504 plans, students who are eligible for services and protections under 504, and potentially the IDEA, the Individuals with Disabilities Education Act, for those issues that fall outside the Individuals with Disabilities Education Act protections. So we're working on that actively. We have a bill title pulled, even though it's September and the session doesn't start till January. We have the legislators lined up. We've been meeting with different stakeholders. We're happy to meet with anyone who is interested about this law. We'll also be seeking people to testify in support of the law once it's in front of the legislature. So if that's something that you're interested in, getting involved more in advocacy, we would welcome volunteers to come to the Capitol or testify virtually to support that law. We also, because of the restraint and seclusion bill that passed this last session, the Colorado Department of Education is working on, and they have to have done by January, rules to implement that new law. Well, the revised law. And the rules that we get out of places like the Colorado Department of Education are typically much more detailed than what the statute said. So there will be an opportunity for public comment when those rules are drafted. So that's another way that we get involved in legislative or in policy advocacy, and that you, if you're interested, could also get involved in policy advocacy in the education space. So those are two of the things coming up that if people are interested, we'd be happy to talk to you more about. And Sarah is gonna give us some practical tips.
All right, so these are just practical tips to kind of take into your school year. And I hope that, they're helpful and that you all have a wonderful school year and no one has any problems. That's what we all hope for. But I'll just talk you through a few different things that we would recommend. The first is just reviewing records. So as a parent, you have right to look at your child's educational records at any time. I think that it's important to, review those regularly, but also especially before things like IEP meetings or 504 meetings. It's really helpful to be able to go into that meeting, knowing what documents you have, maybe what documents you need, and what those different documents say. Maybe there were things that were more helpful and not helpful. And it's really helpful to just look through everything so that you're best prepared as you can be when you go into those meetings. And that kind of goes into preparing in advance. I think, in addition to reviewing records, you can also, take notes on what different things you want to bring up, so that if there's questions you want to ask or different maybe therapies you want to ask about or something like that, that you don't forget any of that information. And so you have all of that there and you've kind of thought through it and you can present it to the team and hopefully make that meeting just a really collaborative way of figuring out how to support your child and that school student. The next one is just to speak up. I think that IEP meetings can be really stressful and sometimes not a positive place for families, and I totally understand that, but you know your child better than anyone, and so I think it's really important to speak up on your child's behalf, on your behalf, and ask for what you need. I think, the other piece of that is that the school district and the IEP team figures out what's best for communicating with you. And if there are needs that you have, make sure that you are asking for those as well. The next tip is just to focus on collaboration and listening. I think tensions can get really high in some of these meetings. And so just you're all there to focus on educating the student the best way possible. So how can you collaborate? What kind of things are they offering that, maybe you hadn't thought about? That kind of thing. The next is to get support. So maybe that's an advocate who comes to meetings with you. Maybe that's a family friend who knows you and your child really well. It could be someone, that can help advocate for your child at the meeting, but it could also just be a family member or friend that you think would just be a calming presence for you to have there, so that you're able to talk through everything that you would like to say in these meetings. The next one is the biggest and most important one, and that is document, document, document. So if there are things that you disagree with, make sure you are documenting that. If the school is maybe telling you one thing and doing another thing, make sure you're documenting that. I think a lot of times there's a lot of conversations that are had by phone and not in writing. I think it's really important to get whatever you can in writing as much as possible. So whether that's an email or whether that's, maybe it's the situation that I was talking about earlier, where the school district is calling you to pick up your child every day or most days. So make sure you're keeping a log of when that is happening, so that way, if you want to pursue any of those dispute resolution options that we were talking about, you have all of that information and you're really ready to go. Then with that, consider dispute resolution. So I think there are a lot of dispute resolution options that are formal and more informal. So there's, some things like as simple as just writing a letter to maybe as low level as your IEP team meeting or your school, but then you could also contact your district special education director or someone more at the district level. Then you could consider mediation. You could consider facilitated IEP meetings. Then you could consider those formal administrative complaint processes, or maybe due process or lawsuits, kind of along the scale of, more informal to formal options. There are a ton of options available to you, probably too many. And I know that can be confusing, but just know that there are a lot of entities who want to help you and want to help the school district work through issues, so that we can really focus on getting your child the best education possible. Keeping the deadlines in mind is really the last bullet on there. And I know I talked about that a little bit in the dispute resolution section, but I totally understand wanting to work through issues at a lower level. I think that is wonderful and recommended whenever possible, but I do think that it is also important to keep the deadlines of those dispute resolution options in mind, because you don't want to, try to work things out at a lower level only to find out that you missed a deadline and things didn't work out and now you can't pursue those dispute resolution options. So definitely try those lower level options, but keep those deadlines in mind. And with that, I think we're going to go to some questions. Angie, you're on mute.
Thank you. All right, so we do have some questions, and Sarah, I think the first one is for you. Someone wrote in, should I be concerned that my child has less rights now because of all the changes?
I totally understand those concerns, and I think that they are valid, but no, your child does not have less rights. Like Emily was talking about, yes, maybe there are different changes that are occurring at the federal level, but the actual federal laws that give the rights to your student have not changed. And so your child does not have less rights, even though all these changes are going on at the federal level.
Thank you. Emily, what privacy laws apply in schools?
Yeah, this is a question that comes up quite frequently, and although we're not experts in records and that sort of thing, did want to flag there is sometimes people think that HIPAA, the Health Insurance Portability Protection Act, I think that's the acronym, that applies to places like hospitals, applies in schools. And it's actually a different law. It's called the Family Education Rights and Privacy Act, or FERPA. That's the law that provides protections around privacy in schools. And that law also is one that you can leverage to get records for a student. It all ties back to educational records. So sometimes there are questions about what is an educational record or not. But if you want more information, there's a good website about the Family Education Rights and Privacy Act with a whole page that's frequently asked questions. And it's www.studentprivacy.ed.gov. So if you have questions around privacy of your student, or if your student and another student have gotten in an altercation and you're wondering if you can get access to that other student's information, I would recommend checking out that website and seeing if you can find an answer to that question there. You're muted, Angie.
Sorry about that. Sarah, do you recommend not filing complaints with federal agencies?
I think, and Emily touched on this a little bit earlier, but we would recommend still continuing to file with those federal agencies. Like she said, what we really don't want is the data to show that maybe these offices aren't needed, because I think that they have been really effective and helpful when they are able to be fully staffed and provide that technical assistance and help families and really, do their jobs the best that they can. And so I think that continuing to file there really will demonstrate the need for these offices, and hopefully we can get back to a place where they are fully staffed and operational.
Thank you. Emily, can children with IEPs open enroll in another school other than their home school? And are schools allowed to deny their enrollment after learning they have an IEP?
Yeah, this is a question that comes up pretty frequently. We actually filed a complaint with the Office for Civil Rights in 2022 because we believe that the way Colorado's school choice laws are functioning is discriminatory towards students with disabilities. There was some there were some changes made to the state law, the Exceptional Children's Education Act, after we filed a bunch of complaints about specifically charter schools asking about disability status prior to admission. And the state clarified that they can't ask about that before admission. And if it's a district-wide admission process, they can't use that data prior to admission. However, once the admission happens, the IEP team does have the capacity to make a determination that that school is not appropriate for that student. They do need to provide parents with meaningful participation, and they need to consider the impact of the location on the child's total educational program. But they can potentially decide that a different school that's not the one that the parent chose is more appropriate for the student. They do also have to include a specific explanation of that determination, either in the IEP or in a prior written notice. So there are some protections, but it is definitely an issue that school choice for students with disabilities is much more limited than for students without disabilities, which we think is discriminatory. The complaint we filed in 2022 is still pending, so we didn't get an outcome on that. But since I'm speaking about OCR again, one thing I forgot to mention when I was talking about the federal changes is that a court recently said that the Office for Civil Rights has to bring back over 200 of the employees that they got rid of. I don't know practically how that's going to play out. I don't know how many of those people have decided they're going to retire, or they've found other jobs in the meantime, or they don't want to go back to the Office for Civil Rights. So while the court order is positive, I don't know how, practically speaking, that is going to pan out.
Thank you. Sarah, where can I go if I have systemic concerns about the way a school or district is functioning and I'm worried about more children than just my own?
Great question. I actually didn't touch on this when I was talking about dispute resolution options, but the dispute resolution options I mentioned, the state complaint process and a complaint through the Office for Civil Rights, they both look at systemic concerns. So, they're obligated to look at a district systemically when a complaint is filed, but I also think it's really important if you're filing a complaint, you can mention, I think this is happening to other kids, or I think this is district wide, and really talk, provide evidence to the fact that you think that it is a systemic concern, and then that will, help keep their eyes towards that as well.
Emily, where can the audience get more information about student rights?
Thanks, Angie. And thank you everyone for being here tonight and bearing with us as we got our technical difficulties sorted out, but we are still going to end just right about on time. But before I let Angie close us out, for more information, please visit our website, www.disabilitylawco.org. We have a lot of self-advocacy materials there to help people take the next steps that they need to take in order to advocate for themselves and their children. So thank you very much.
All right, that brings us to the end of tonight's program. First, a big thank you to Emily and Sarah and to all of you for taking the time to join us. We know how busy the start of the school year can be, and we're grateful that you made space for this conversation. As you've heard, there's progress to celebrate, but also challenges ahead. Students with disabilities and their families still face barriers, and it will take all of us, parents, educators, advocates, and community partners to keep pushing for equity and opportunity. If you'd like to stay engaged, please connect with Disability Law Colorado. Share our resources, join our advocacy efforts, or support our work so we can continue to protect and expand the rights of students across the state. We're on Facebook, Instagram, and LinkedIn. And we also have a Colorado Gives Day QR code if you are interested in supporting our work. And we will also send you a recording of the session that we just did next week. So keep an eye out for our email. And thank you again. And remember, change happens when we work together.